Loud little ducky coming through, spitting truth, unabashed, calling out the liars, debunking falsehoods with a blast. I ain't afraid to say what's real, won't ever hold back. Gonna shake the system up, turn it all off track. I see through the smoke, the mirrors in the disguise, expose their hidden agenda. No more room for their lies. The truth is my weapon, I won't let it be concealed. I'm the voice for the voiceless, no longer gonna yield. In a world full of deception, I'm here to set it straight, bringing justice to the forefront. Won't accept their twisted fate. They may try to silence me, but my voice will still prevail. A sparking revolution, it's a truth-telling tale.
Welcome back to the Loud Little Ducky. I have not seen. I am blindly reacting to these. Hopefully y'all can hear me. Don't forget to like and subscribe. We are so close to 1,000 subscribers, my little ducklings over here. All right. Let me... Okay. I have so many tabs open that I don't need to have open right now. Because I'm doing research for another case. All right. Let's bring this over here. Okay. Let's present this. I'm getting a light for my laptop. It's supposed to come in today so that I'm not quite as grayed out because my light in my room is god awful. Share screen. So hopefully that'll help that at least. And here we go. There should not be any audio. Okay. Good. Thank you for letting me know you can hear me. I'm trying not to be so close to the mic, and I'm hoping I can be further back from the mic so that sounds that I make when I'm talking, I guess, aren't annoying people with misophonia, which I completely understand. All right. So Omar filed this on October 13th, 2025. Of course, it's in the Superior Court of the State of California, County of San Francisco. And Omar, as we know, is the attorney for Mike Marraccini, going against Laura Owens pro per as of now. Judge Carolyn Gold, who sounds like she's a no-nonsense type of person, is the presiding judge over this case. And this is going to be Marraccini's witness list. Well, thank you. Everybody say thank you to Steve. He has been a great resource. Recently in this case, he goes to the court hearings for us because they are not televised. He is the one that gets the court documents for us because they are public record. So there's no leaking of court documents just so people out there, certain attorneys and a certain petitioner in this case, don't think people are leaking things. No, we wait for them to become a part of the docket, and then we get them when they become public. We're doing things the correct way. All right. So let me get better. All right. So thank you again, Steve. So appreciated. I've been waiting. I was wondering if these were even going to be uploaded because of the strike, but thankfully they were. All right. Now, okay. No, that makes me. No, don't maximize me. No, I don't want that one. All right, we'll just go to this one. Sorry. Okay. So Mike Marraccini is the number one witness, and he is also the respondent. The purpose is to testify regarding the history of the relationship with petitioner, denial of all abuse allegations, compliance with prior DVRO order, and evidence petitioner fraudulently conducted and retaliatory motive. The estimated time for his direct, so just Omar's part, is about 60 minutes, is what he expects. And then I guess we'll see how long Laura will spend on him. Right? It's like, oh, the tea. Then the number two witness, because no, she is not number one. No, Laura Owens is not number one. Maybe in her world, but not ours. She's the petitioner. She is going to be called adversely under Evidence Code 776, which is going to be I'm thinking this is going to be considered a hostile witness, even if she's not hostile. Okay. Adverse or opposing. And by doing this and calling him as an adverse witness, this gives Omar the right to basically cross-examine her in his case in chief instead of having to be doing a direct examination of her where he couldn't ask her leading questions. So she should be able to be treated as if she was on cross-examination, but he's calling him in his case in chief to prove things. Because if she decides not to call herself, which to me would be stupid when you need to testify about all this shit, he is calling him for his. So the purpose for this cross-examination regarding prior false statements under oath, fabrication of evidence, pattern of fraudulent claims, and the absence of any objectively reasonable fear of future abuse. Her estimated time for cross is 120 minutes, which is 2 hours. So Omar is giving himself 2 hours to cross Laura Owens, which is crazy because that's Laura Owens being on the stand the entire time, basically, that it took in the Owens v. Eckerd hearing is just going to be dedicated to Owens. And I think that's good because he is making sure he allots enough time that if she tries to do delay tactics and everything else and, she's not forthright and wants to play games on the stand, he is making sure that he is allotted enough time for that because she's not going to just be she's not going to be direct. She's not going to answer up front. She is going to be a pain in the ass witness because nothing is ever her fault. Then we have Greg Woodnick, Daddy Woodnick, family law attorney. He is for the purpose of rebuttal, which rebuttal is once Laura should get to go first because she brought the petition and she is the burden of proof is on. So she would go first and she would do her witnesses and everything like that. Then Omar would do his. And then Owens, if she wants some rebuttal witnesses, she could if she wants to combat anything that was done. And then Omar should be able to rebut those small things. So we'll see. I mean, I don't think Marraccini would go first. I think Laura would. And his purpose would be expert opinion on petitioner's pattern of fabricating abuse allegations, misuse of court processes, and unreasonable fear under Family Code 6345, corroboration of findings in Arizona paternity litigation. And his estimated time is 30 minutes. Right. I just wish sourdough rain. I wish we got to see it. I mean, Steve will get to see it, but and Megan Fox is going to be there as well. She gets to bring her laptop in. None of it is live streamed. There won't be any video tapings of anything. We're not sure right now if she can do live tweeting. I'm thinking probably not, but at least she'll be able to take like notes herself while it's going on and not just remember it for later. So she gets to be our little court reporter. And so I'm very excited. Then we have John Berryhill, who is the digital forensic expert. He's the one who a bunch of us donated to Mike Marraccini so that he could get his laptop forensically analyzed. And John Berryhill is the one who did that. And so his purpose is expert testimony confirming that multiple documents and digital exhibits submitted by petitioner were fabricated or altered, including falsified medical letters and ultrasound images. And his estimated time is about 45 minutes. And he did submit earlier a thing that we've gone over. What did he? I don't know what he called it, but we've gone over the thing that Omar already submitted about John Berryhill being a witness or an expert witness. It was like notice of an expert witness. Then We have number 5, Terry Bowe, Arizona investigator from Maricopa County Attorney's Office. Purpose: to testify regarding the criminal investigation of Laura Owens, culminating in May 2025 grand jury indictment charging her with fraudulent schemes, forgery, perjury, and evidence tampering, to explain the investigative findings showing a deliberate pattern of deception relevant to credibility. And his estimated time is 60 minutes, so about an hour to go over that. And which is great that Terry Bowe is going to come and do that. Um, I haven't I don't know if he's being subpoenaed or if he's just agreed to do it, willingly. And if he's done that, props to him. Yeah, and Calamity, like, they do have a court reporter and transcripts. They have that. Um, we could find out how much those transcripts cost and get our own transcripts if we wanted to, and then we could do, like, a reenactment stream maybe with Megan Fox and Lauren Knighty and Bruce and maybe Brad and Schnitzel Ninja. We could all like, and Dave, if we got the transcripts, it would probably take forever to go over them, but that is something that we could get. There will always be a court reporter and transcripts in any hearing that ever happens in court. And Gingras can lie all he wants to, and we can listen to what he says. We don't have to believe it, but if he says stuff, we can listen to it and see his side of things. And we also will listen to other people, and we get to decide who we believe or if they're saying the same things. And in the end, if she loses, he's just gonna say, "Well, it's not, she lost because of an online cult." And every time she loses, it's never it's everybody's fault. It's the cult's fault and a biased judge or unfair hearing. Um, yeah, that would be cool if Gingers was kept out as well. He may just be on Zoom, but his testimony is not going to change whether he's listening in on all of it or not. And usually that's the point, is so that the testimony is not going to change. David knows what he's going to say. It's been scripted since before June 10th, 2024, when all this went down. Yeah, he shouldn't be able to coach her. So if he is there in person, that is something that definitely shouldn't be allowed. He shouldn't be able to sit at counsel table or anything where she can see him from when she's on the stand. All right. Then we have Clayton Eckerd, a fact witness, victim of Owens. Purpose is to describe petitioner's false paternity and abuse claims against him, her use of forged evidence and identical behavior patterns demonstrating lack of credibility and absence of genuine fear. Estimated time 60 minutes. Greg Gillespie, fact witness, victim of Owens. Purpose to testify regarding petitioner's false pregnancy and abuse allegations in 2021. Submission of a forged ultrasound and retaliatory misuse of protection orders Further evidence of her fraudulent pattern, estimated 60 minutes. Joan O'Neill, a recanting witness. Purpose: to testify that her 2018 declaration supporting petitioner's DVRO was false and authored by petitioner. Establishing extrinsic fraud in procurement of the original restraining order. Estimated time 20 minutes. Wow. Jan O'Neill, who at one time or another was on Laura's side, she is saying that the petitioner is the one who wrote the declaration of support. Not herself. So, forging court documents. This will be on record. So, California, y'all need to be paying attention. This was dated October 7th, 2025. All right. And here is respondents' exhibit list. So this is Mike Marraccini's exhibit list. Respondent Michael Marraccini, by and through counsel, herein submits her list, should be his list of exhibits anticipated to be used during this procedure. Respondent Michael Marraccini reserves the right to amend this list up until the day of trial. So stuff could be taken off, stuff could be added. So they've got Exhibit 101 is the under advisement ruling from the Superior Court of Arizona issued by Judge Julianne Mata on June 18, 2025. They've got the criminal indictment from the Superior Court of Arizona that was filed on May 1st, 2025. Correspondence from, this should be June 18th, 2024. Because it took them a whole year to basically indict her. So Mata put hers out on the 2024. And then she was arrested May 1st, 2025. Then correspondence from Dr. John Chung Kai Chan, MD, on August 13th, 2016. Correspondence from Dr. Rebecca Yee, MD, on August 31st, 2016. We have seen these letters. Exhibit 105, San Francisco Police Report, case number, picture of investigating officers, which we've seen that picture. Exhibit 106 is an image of Laura with redness around her face, particularly her right eye. She does look like she has a black eye in that photo. I will say that. It looks like it's healing because it's not like, it doesn't look fresh. But that's where she's trying to say she had petechiae, which she did not. Oh, I will be reading Laura's as well. Oh, I fully expect dirt. Because, again, nothing is ever Laura's fault. Nothing. She is perfect in every way. She watched Mary Poppins way too much. What just happened here? Oh. I just got a phone call. Let me see if I can have the I just got a phone call. I'm contacting you about your written charge submission to our office, but about Mr. Gingras. And then I am to call them back. So I filed a complaint about David Gingras, and they just called me while it was on stream. So as soon as we're done here, I will be calling them back. All right. Continuing on. The John Berryhill digital forensic report from May 4th, 2024, the chicken soup for the sole published flight story from the event that occurred on December 30th, 2016, petition for order of protection against Clayton, filed October 6th. 2023, subpoena issued by Superior Court of Arizona to Michael Marraccini, CO, as well as Randy Sue Pollock. Civil complaint against Greg Gillespie, filed by Laura Owens on August 11th, 2011. 2011? 2021? I think 2021. Okay, there's some date mishaps in here. 2021. Petitions for order of protection against Greg Gillespie, filed by Laura Owens on November 12th, 2021 and December 6th, 2024. Positive pregnancy test by Laura on August 19th, 2016. I'm sure that's a picture, not the pee stick. Let's hope so, because ew, gross. Text messages by Laura Owens claiming concerns of a miscarriage on July 14th, 2016. Text messages by Laura Owens claiming concerns of miscarriage and on her way to the hospital on July 15th, 2016. Exhibit 116 is a Facebook post with Laura Owens at KGO celebration for Ron Owens on July 15, 2016. Text message by Laura Owens claiming her twin pregnancy was no longer viable and that she would take abortion pills on July 22nd, 2016. Text message by Laura Owens claiming the abortion pills did not work on July 28th, 2016. Laura Owens' deposition for the Eckerd paternity case, where she claimed she saw Dr. Chan, where she had an oophorectomy and was treated for ovarian cancer. That part we have not seen. We have seen the transcripts for it, but we have not seen her say this. Exhibit 120 is equestrian rider reports during 2016. Petition for order of protection by Greg Gillespie against Laura Owens, filed on August 21st, 2021. Text message from Laura Owens to Michael Marraccini on July 6, 2016, stating she loves and trusts you. Then there's more text messages of Owens saying, love you, I'm horny, I wish we could get dinner on May 19th, 2017. Email from Laura's attorney, David Gingras, stating Laura will speak with him directly, a violation of the current restraining order on May 8th, 2024. It would be, very much so. And I think it was to try to set him up to violate, in my opinion. Laura sent inbox contacting tips about Clayton Eckerd paternity update, stating she is the anonymous woman around 2023. State's notice of disclosure and request for disclosure filed by the state of Arizona, filed on June 25th, 2025. Text messages by Laura regarding inpatient psychiatric therapy. A declaration of Laura Owens on May 29th, 2018. Findings after trial by Judge Mata. Petition to court order paternity filed by Laura Owens on August 1st, 2023. And Omar signed this October 10th, 2025. And that is Marraccini's documents and witness list. I am not calling and doing it on live just in case there's information that's not supposed to be out there. I don't want to mess with any investigation that's going on, and screw it up to where they maybe can't do something. I know, but if there is stuff that I can share, eventually I will share it. But they could just be telling me, this isn't relevant to us, ma'am. I mean, they could be telling me that, but we'll see. All right. Okay. All right. Now let's remove this and stop sharing this, and then we'll go back to the documents. This makes me... All right. Let's go to the witness list, and hers is 8 pages. Yeah, I figured we could get this done fairly somewhat quickly just because they're kind of short documents. All right. So, everybody, oh, let me try to make this bigger. I don't know what just happened here. Okay. That was weird. Okay. So, Laura Owens, pro per, she filed hers December 13th, 2025. She listed October 21st and 22nd. So her number one witness is David S. Gingras, Esquire, because he is her numero uno. Former counsel, Owens v. Eckerd, Maricopa County Superior Court, and fact witness, which, is he former counsel or is he her counsel in another case? Because he should be the one that is responding to what Woodnick just filed in the Owens v. Eckerd case about her finances. He should be the one responding to that stuff so he is still counsel if he's still working on that case for her. She says that David Gingras will take about 60 minutes. Oh, good God. Attorney licensed in Arizona and California who represented petitioner in her 2023 to 2024 paternity case against Clayton Eckerd. Mr. Gingras is expected to testify as a percipient witness regarding respondents' continuing violations of the San Francisco Superior Court DVRO. And the case number, Mr. Gingras will testify that on April 19, 2024, respondent's attorney, Randy Supalik, confirmed in writing that my client will not be testifying in the Arizona paternity case. Despite his assurance, respondent traveled from California to Phoenix and appeared in person at the Maricopa County Superior Court on June 10, 2024, where he sat approximately 20 to 25 feet from petitioner for over 2 hours while she testified, without permission from the issuing court and in direct violation of the active San Francisco protective order prohibiting all contact. Well, he had permission from Judge Mata's court, because Judge Mata said, okay. And from what Steve reported, the judge in this DVRO renewal kind of feels the same way. They have bailiffs. She's safe. Everything is fine. Mr. Gingras immediately contacted court security and local law enforcement after petitioner became visibly distressed on the stand, providing documentation of the active order and requesting enforcement. You did not become visibly distressed because Marraccini was there, unless you were like, "Oh shit, they're really going to bring up my fraudulent doctor things." Following this incident, respondent publicly admitted in a recorded interview with media figure Megan Fox that he attended the hearing knowing he was not going to testify. But he didn't know if there would be time for it. He didn't know that he wasn't going to. Mr. Gingras also possesses knowledge of respondent's involvement in providing a laptop to forensic examiner that resulted in a 2,489 page extraction of petitioner's private text messages, which were leaked online to the group Justice for Clayton, which is dedicated to harassing petitioner. Okay. They're not private. They don't have to be private anymore because you're accusing him of stuff and he has the right to defend himself. And if those pages are what shows that you're a liar, in my opinion, he's allowed to do it because truth is a defense. And nobody has contacted you about these things. You have gone and looked at things about it, but nobody's like, "Hey, this." Nobody's tagging you in this stuff. I didn't realize that was two 2,500 page thing. Is that it was also an exhibit in or something that was going to be an exhibit in the trial. But anyways, number 2, Mike Marraccini, respondent in underlying DVRO, San Francisco Superior Court case. She thinks that he is going to take 90 minutes for her to cross-examine. Expected to be cross-examined regarding his continuing violations of the San Francisco Protective Order, his repeated public misrepresentations about petitioner, and his ongoing use of coercive control and reputational abuse to circumvent court restrictions. He has no coercive control over you. And Mike didn't ruin your reputation. You ruined your own reputation. Oh my God, this bitch. I didn't realize it was 2,500 pages either. Unless that's what that Reddit thing was. I don't know if that was all of them or what, but yeah, he called police before the court started for sure. No, I think she fully wrote this. I think David helped her, or she took stuff from other court filings and put it in this, but I think she definitely wrote this. I mean, if Gingers wrote this is bad. All right. Let's go back. That's not what I want. All right. Respondent has engaged in a sustained campaign of post-separation harassment, including a 2.5-hour interview with media figure Megan Fox, during which he discussed the protected case, disclosed private details about petitioner's mental health, and made false, humiliating statements designed to damage her reputation. He didn't have to damage your reputation. You did that yourself. You cannot damage an already ruined reputation. And you're one to say somebody made false statements. You're going to have to prove that he made false statements. And what private details about your mental health? Private details that were in your public court filings for the DVRO? in forged documents, like you're going to have some explaining to do about this stuff. In that same interview, respondent admitted that he traveled to Arizona for June 10th, 2024. Owens v. Eckerd hearing, despite knowing he wasn't going to be testifying. He neither sought nor obtained authorization from the issuing San Francisco Superior Court in violation of the active cleats restraining order prohibiting contact and proximity. His deliberate disregard for the order and court jurisdiction constitutes a willful violation under 18 U.S.C. 2262, interstate violation of a protection order, and Family Code 6320, reflecting ongoing coercive control and intimidation. No, he did not. You're just pulling shit out of your ass. This is make-believe. Respondent also leaked or authorized the publication of private text messages between himself and petitioner, communications covered by the DVRO to third-party online accounts associated with the Justice for Clayton network. These acts were intended to retaliate, harass, and humiliate petitioner. No, they were in furtherance to defend himself and tell his story for once, because you want to silence people. You don't want people telling stories about you. He says that is in direct violation of the spirit and purpose of the protective order. I don't know what the spirit of a protective order is, but the spirit needs to come visit you. In pleadings filed through counsel, respondent further alleged that petitioner traveled to New York to confront his employer's HR department and asserts that she has pressured or pursued communication, harassed, and publicly confronted him. Claims that are entirely false. Petitioner has had no contact of any kind with respondent since 2018, has never known his employer's name or address, and has not initiated or encouraged any communication or confrontation. Do they have videotape of her going there? I want to know how they're going to prove that part, because Omar did bring that up. But she's saying right here, I did not go. Is that going to be another lie? These knowingly false statements to the court illustrate respondents' ongoing fixation and continued efforts to weaponize litigation and public narrative to punish and defame petitioner. I'm curious about this one. She's denying. She is denying that she went to Marraccini's work. So how did Marraccini find out about this? Yeah, no judge wants to read that 2,500 pages of anything, but definitely not that conversation where it's just repeated bullshit. Yeah, I think we're going to have to add another witness or rebuttal witness for this. All right. Now she has number 3, which is going to be a family witnesses, which she wants to call Peggy Marraccini and Stephanie Ash Marraccini, now Scanlon. Well, are you subpoenaing them? Because they're not just going to willingly show up and be on the stand for you. Like, if they don't want to testify, they don't have to testify. Unless you subpoena them. So you might want to get on those subpoenas, Laura. Respondent's mother and sister, 45 minutes total. So Stephanie actually married Colin Scanlon. I didn't know if Stephanie and Colin were still together. They're expected to testify their close and frequent relationship with petitioner during her relationship with respondent, including multiple family gatherings, dinners, and shared events between Marraccini and Owens families. Both women personally witnessed petitioner experience a grand mal seizure in Petaluma, California on May 13, 2017, shortly after an incident of physical abuse by respondent. Okay, just because they saw you have a grand mal seizure, and did you go to the emergency room after this seizure? Is there a medical record, legitimate medical record of you doing this? And just because you had a seizure did not mean that that seizure came from abuse, because your text messages say otherwise. Your Uber lawsuit says otherwise. So she says, Peggy Marraccini sent her son a text message the following day stating, I don't want you to be my son because of how you treated her, which even respondent's own witness, John Berryhill, acknowledged as authentic. Her contemporaneous messages to petitioner described her as so loving and caring and so blessed you are home with your sister and daddy, confirming the seriousness of the relationship and undermining respondent's current claim that it was casual or delusional. No, they dated for a while. I don't I don't think he called it casual. Maybe he did, but no, they to me they weren't casually dating, Marraccini and her. Maybe she's getting her lawsuits mixed up with Greg Gillespie, because they casually dated. Petitioner also retains multiple voicemails from Miss Marraccini, many recorded after she had distanced herself from respondent, in which Miss Marraccini pled for renewed contact, reflecting both emotional distress and implicit recognition of her son's culpability. She may not have known the whole story back then. She may not have realized everything, because guys don't always talk to their mom about things like that. But even girls, if we have a partner who is not always great to us, then we usually try to say things that make our parents think of our significant other in a good light. And then when you start letting your parents know basically that they're a piece of shit, that's when you know it, um, the relationship is going bad, is when you finally let your parents know how bad the relationship actually was. So Mike Marraccini might not have told his mom about certain things, um, because maybe he didn't want her to know that he was with a crazy woman. Um, but the judge did say that she doesn't care about anything that happened before the first DVRO. She wants to know what happened between 2020 to 2025. And rehashing the relationship is not a part of that. If they were going to allow her to rehash it, then maybe they would be relevant, and maybe Omar would have called them as well. But I think they're going to be considered not relevant. How do they pertain to anything that's happened from 2020 to 2025? So in the last 5 years. Stephanie asked Marraccini, now Scanlon, also socialized frequently with petitioner, borrowing her car, dining to. Yes, of course. They are going to have been close with you while y'all were in a relationship for an extended amount of time. They're going to have had good times with you, obviously. So they, just because they liked you and got along with you at one point when you were dating their brother or son, doesn't mean that you're not a fraud who schemes and manipulates. dined together, exchanged messages acknowledging respondents' validity. Since 2023, Ms. Scanlon has aligned herself with online harassment networks defending respondent and targeting petitioner, including Justice for Clayton. Well, she has that right. Posting under the handle Justice for MM. How do you know that is her? Has she said that that is her? She has publicly identified herself as respondent's sister and leaked previously unseen photos she personally took of petitioner to the Justice for Clayton official Instagram account, Justice for Clayton official. These images included from May 2017 horse show and a private birthday dinner, confirming her as the original source of private material later used to harass petitioner. It was not used to harass you. You do not understand what harassment is. Just talking about a person is not harassing somebody. Go read up on what harassment is. And don't use Urban Dictionary. Taken together, Peggy and Stephanie Marraccini's prior statements, actions, and communications provide direct, independent corroboration of respondent's abusive behavior and evidence of coordinated ongoing efforts by his family to intimidate petitioner and undermine the protective intent of prior court orders. Their testimony collectively supports renewal under Family Code 6345 by demonstrating that the abuse has persisted both directly and by proxy. Mike has no control over what his sister does. And Mike's sister sure as hell did not tag you in anything. She didn't send you this thing that says, hey, I'm going to be talking shit about you. They're not sending you this stuff. You are actively searching for people talking about you. And are they private, or were they a part of stuff that's on Facebook that you do not have privated? That is it's out to the public. Oh, Callie Sapskinski, now McLean. Did she say she was going to come testify for you? She knows that she needs to subpoena these people, right? Or are Callie and her just best friends now, and they have been ever since Marraccini and Callie broke up? Like, this lady is friends with you now? After you kind of kept running into them and then you reached out to her and Facebook stalked her? She thinks this one will take 15 minutes. Former intimate partner of respondent who independently contacted petitioner to confirm that petitioner's prior warnings about respondent's behavior were accurate. In her messages, Ms. McLean stated, some things happened and I would prefer to stay far removed from him, and I just wanted to say thank you for giving me the heads up on Mike, and I apologize for not believing you at the time. Woman to woman, I just want you to know that I appreciate what you did. She also wrote that she blocked him on every platform to avoid further contact. Okay. Although communication occurred in 2018, Ms. McLean's account remains highly relevant under Family Code 6345 because it independently corroborates the long-term pattern of coercive control, emotional, volatile, and retaliatory behavior that continues to drive petitioners' ongoing reasonable fear. Okay. Her testimony provides objective and validation from a separate partner who, after direct experience, chose to sever all contact for her own protection, underscoring that respondent's behavior presents an enduring threat, not an isolated past event. Well, Steve, I guess I want to hear all about this lady. And if she is forced to come in to testify, if she actually shows up to testify and is a willing participant on behalf of Owens, um, because let's just say that maybe Laura had a right to do something, and maybe Mike was scary to Laura because he raised his voice to her or something. Um, but what has he done in the last 5 years to have this DVRO renewed? I think he will too. Um, but we don't have a response to this witness list. That's stuff that'll be done in court next week. Yes, I would love to hear about that, Steve. I would love to have you come on and talk about these people because she has all these people listed. And so they've either agreed to come of their own free will, or she's just listing people that support her from back then. And they're like, no, I'm not coming to testify. And she's going to need to subpoena them if they are not willing to come testify on her behalf. Yeah, she manipulated everybody because she can come off as, sweet, caring. Just look at me. I mean, we see how she acts when she's done like podcasts and stuff. Man, if I lived closer, I would so be there for that. I don't have the money to go and get a hotel and a plane ticket to go to this hearing, but man, if I did, especially with wanting to go to her criminal trial. Okay, let's continue on to the next one. Now, this person I somewhat believe is going to come testify for her willingly because she can fool all these equestrian people. Julia Brozick, competition safety coordinator, United States Equestrian Federation, USEF, 20 minutes. I don't know what this has nothing. None of these witnesses right now have anything to do with 2020 to 2025. These witnesses would be good for her if this was about vacating the entire DVRO and its premise being fraudulent. But as of right now, that is not what is going to be happening. They are only here to discuss the renewal, not vacating the original thing. So these witnesses right now have nothing to do with 2020 through 2025. She's expected to testify as neutral records custodian and expert witness regarding petitioners' official United States Equestrian Federation, USEF competition history, safety logs, and incident reports. In respondent's motion to dismiss DVRO pursuant to CCP 47.3BD, his counsel alleged that petitioner rebranded horsefall injuries as domestic violence bruises, citing competitions in February of 2017. Ms. Brozick will testify that USEF's official safety records reflect no reported falls, injuries, or on-site medical incidents involving petitioner at any USEF-sanctioned competition in 2016 or early 2017, including those cited by respondent. The only recorded equestrian-related event occurred on May 2017, when petitioner experienced a grand mal seizure while mounted at the walk on a horse at USEF-sanctioned competition in Petaluma, California. She fell as a result of the seizure, not a riding error or accident, and was treated and released the same day without overnight hospitalization. The incident was witnessed by Peggy Marraccini and Stephanie Ash Scanlon, and independent observers confirmed that they were present and followed petitioner by car to the hospital. There's only one video and one event that she's ever fallen at. Is there video evidence that there's more than that? USCF's mandatory reporting protocols require documentation of any rider fall or medical transport. No such records exist for petitioner at any other time in her competitive history, confirming that she has never been hospitalized for any fall reported in USEF competition logs or in general. This neutral governing body evidence directly disproves respondents' claims that petitioner's injuries were equestrian related and reinforces eyewitness accounts showing that her May 2017 medical emergency was the result of a seizure, not a riding accident. Okay. Well, if that's true, then okay. Yes, Schnitzel. I can see you now. Sorry. Yes, Schnitzel. Okay. Thank you. Uh, 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 uh. Joni's paragraph. Okay, let me. So don't go over that one. Okay. Um. All right, hold on. Okay, when I get to that one, we'll go to it. Okay. Yes, please message me somewhere, whether it's email or at loudlittleducky@gmail.com or Twitter or wherever. Or Lauren has my phone number that you can get from her and text me. All right. Well, we just don't want to spread false information and stuff. And if that's a request, then that's what we want to do. All right. Then we have Napkin Lady. Neutral third party eyewitness who personally observed respondents' verbal and emotional abuse petitioner on an international flight in December 2016. Miss Bernatis wrote contemporaneously that respondent was so menacing that I felt her life was a stake where if she were to stay with him, and then slipped petitioner a note urging her to seek help. Well, if you're blubbering for the whole plane ride, then yeah, she's probably worried about you. In 2023, Miss Bernatis publicly recounted the same event in the Chicken Soup for the Soul, Get Out of Your Comfort Zone. We did go over the Napkin Lady story. Writing the situation was so dangerous that I couldn't even risk sharing my phone number. I still don't understand that, but okay. Her recent publication provides contemporary corroboration that an uninvolved stranger perceived respondents' conduct as life-threatening, supporting the continuing reasonableness of petitioner's fear and need for the renewal of protection. Yeah, let her testify. because Omar and all of us have some questions for Napkin Lady. All right. Then records custodians, Child Protective Services and Human Resources Department, respondent's employer, New York, 20 minutes total. Expected to testify or provide certified documentation regarding two discrete factual issues raised by respondent in his proceeding. First, the Child Protective Services, CPS, records custodian or assigned investigator is expected to confirm that a CPS report concerning respondent was received and investigated in 2024. Petitioner was not the reporting party, and CPS records confirm that neither petitioner nor any members of her family was identified as such. Was Gingras? Hmm? Was a friend of the family? Was it Uncle Jojo? Just because it's not you doesn't mean that you didn't have somebody do it. The report's existence became public only after respondent and his online affiliates discussed it on Reddit, falsely accusing petitioner and her family of making the report. Well, they're going to have to they're going to need that discovery. Okay. Um, I mean, people can have seizures and not have some of that stuff. Um, okay. Yes, I do what my leader tells me to do. Okay. All right. So that is oh, it says in reality, the report originated from an independent third party who found respondents' conduct sufficiently concerning to alert authorities. The fact that a neutral observer viewed respondents' behavior as warranting a CPS report supports the inference that others, not only petitioner, continue to perceive him as threatening. If somebody called CPS on somebody for him doing an interview or going to a court hearing, you're a piece of shit. I will tell you that. Because if you did not see this man doing something to his children, you're a piece of shit. You do not do that. His interview or him going to a trial or a court hearing where he was subpoenaed to go is not a reason to make a CPS report. So this so-called independent third party who saw behavior, it better had been for him doing something to his child, not just you calling like, oh, this pisses me off. Okay. Like No. Napkin Lady shouldn't have been one to report this either because these people shouldn't know anything about Mike and his children. Okay. Not only petitioner continued to perceive him as threatening. Respondents' subsequent effort to weaponize and publicly mischaracterize the report further demonstrates his ongoing use of intimidation, deflection, and reputational abuse, all consistent with coercive control under Family Code 6320. He is not controlling you. Obviously, you're able to speak and talk about whatever you want. So he has no control over you. And it's not a far-fetched conclusion to speculate that you or your family member reported this as retaliation or somebody you know. If it's somebody just from in his town and they saw something, okay. Second, the Human Resources Department, records custodian, or designated representative of respondent's employer in New York is expected to confirm that petitioner has never contacted, visited, or communicated with any HR personnel, and that no record, visitor's log, or correspondence supports. Respondent claims that she made an impromptu stop to discuss the existence of the DVRO. This verification will establish that respondent's allegation was entirely fabricated and reflects his ongoing attempt to distort facts and portray himself as the victim. Well, hopefully Omar wouldn't have said it if he didn't have proof of it. Because a he said, she said thing isn't really going to work. There needs to be evidence corroborating this information. And says collective, these neutral record verifications provide objective third-party evidence disproving respondent's false claims and corroborating that his conduct continues to generate concern and fear in others. This supports renewal under Family Code 6345, demonstrating that petitioner's ongoing fear in 2025 remains objectively reasonable and well-founded. Okay. So I'm going to take this down. All right. Real quick, and I'm going to go past. Okay. Going past Joni's stuff. Please do not reach out to anybody on this. Because we do not need more victims of Owens. Do not harass anybody. Don't contact them. Follow the court case. Hear what is said in court, and that's it. And if Laura can prove some of these things, then okay, she can prove some things. A clock is right twice a day. A broken clock is right twice a day. So just please don't do that. All right. Miss Ariana Huffington, she says this is a rebuttal. Witness, 5 minutes. Public figure known to petitioner's family through her father's professional career. Miss Huffington will confirm that she has never met, spoken with, or interacted with respondent in any capacity, directly rebutting respondent's false public claims of association and thereby impeaching his credibility. She never met, spoken with, or interacted with respondent in any capacity, directly rebutting respondent's false public claims of association and thereby impeaching credibility. Her testimony will demonstrate respondent's ongoing pattern of fabrication and self-aggrandizement, further undermining the reliability of his representations to the court and the public. A public figure that says she has never interacted. So I guess Mike has said he has interacted with Huffington. I don't know. Okay. I don't know when. Okay. Now we get to one that she says she's going to do a subpoena to be identified via subpoena to Meta Platforms Incorporated. Well, that's great if you subpoena to Meta, but you're going to have to, Meta's going to have have a court order or something for them to tell you who the person is behind Justice for Clayton and victims of Laura Owens. And so you're going to have Meta come testify on your behalf? Okay. I don't see that happening. Like, girl, you know your trial, your hearing is next week. And you are going to get Meta to testify for you. And you're also going to find the owner and operator of the Instagram accounts and subpoena them. Like, what? And she still has to file for permission to travel. Well, I mean, the stuff being posted on Instagram, I mean, she thinks that it's like Mike Marraccini behind that. I don't know anything about Ariana Huffington. Yeah, Meta is not exactly somebody that like just willingly participates with courts and law enforcement and stuff like that. And this witness list of you making these statements doesn't make any of it true. No, I know it's not Mike or Greg. Okay. She thinks this is going to take 30 minutes. I would like to know how these people are getting there and how she has to pay for them to be there, or, I mean, they can Zoom, but okay. But they are expected to testify regarding the authorship, operation, and content sourcing for the Instagram accounts Justice for Clayton Official and Victims of Laura Owens, which have each engaged in coordinating online harassment, defamation, and indirect contact directed at petitioner in those people are not in violation of a San Francisco DVRO. You do not have a restraining order or domestic violence, nothing against the owner and operators of an Instagram account. So they don't have to do anything in regards to a court. And if you want to sue them for defamation, then you can do that. But you don't get to just, they're not in violation because it's not Greg or Mike or Clayton running these things. So they haven't violated shit, Laura. You can't, everybody is not under a code of silence just because you have people that we're talking about trying to be silenced. Like, that's not how this works, because we're not doing it at the direction of any of these people. We're doing it of our own volition. Petitioner intends to subpoena Meta Platforms Incorporated to identify the subscribers. Well, you should have done that a long ass time ago, because this ain't happening. Registered email addresses, IP addresses, and device logs associated with both accounts, as well as uploaded metadata for posts compiled in Exhibits 22 and 23. Ma'am, they're not handing you anything, and they are not going to identify them to you because you want that information for a court filing. You're going to have to ask the judge. The judge is going to have to grant something, and then you could do this. But they're not going to give you this information without a court order, and you don't have one. The operator's testimony is necessary to authenticate the record's confirmed content origination and establish that respondent and or his counsel provided, approved, or directly coordinated the dissemination of materials used in the posts. Nope. They're not going to authenticate and establish anything to do with Mike Marraccini or Omar. That page has been around since Omar was even on this case. Not just this case, but anything related to Laura Owens. The operators are expected to testify regarding how private materials, including photos, videos, and screenshots known to have been in respondents' or his relatives' exclusive possession, were obtained and uploaded. How is Meta going to help you say that they were in the respondent or a relative's exclusive possession? His relatives are not under a restraining order either. Mike can't tell them to do something, but if they are just speaking out against you or combating your lies, that doesn't mean that Mike is doing anything. How respondents' unserved legal filings, including his CCP 473BD motion, appeared on victims of Laura Owens before petitioner was served, with captions stating filings coming soon, approved by attorney, and his legal team has confirmed it. Okay. Oh my God, he gave you a publicly filed document or a document that was going to be publicly filed? Okay. Who gives a shit? That's not harassment. That's not breaking the DVRO. Reflecting insider access and active communication with respondent or his counsel. Just because they are like, yeah, you can have this public document doesn't mean anything. Any communications or coordination with respondent, his relatives, including Stephanie Marraccini, now Scanlon, or representatives concerning the publication of posts targeting petitioner, metadata or message logs establishing that respondent or his legal team directly uploaded, authorized, or supplied content used to harass petitioner, including court pleadings, sealed materials, and defamatory statements. Oh my God, this is a heap of shit on this one. Like, okay. The account's coordination with respondents' public appearances, statements, and filings showing that posts were timed to coincide with respondents' interviews and legal actions. Okay, I don't know where you're going to get proof of all this. This testimony will authenticate Exhibits 22 and 23 and establish that respondent has maintained ongoing communication with the operators of both accounts, constituting indirect contact, harassment through third parties, and disturbing the peace under Family Code 6320. If she's relying on Meta for this, it's like she's going to be severely let down. You know who might have this information, though? that possibly got it through a subpoena. Okay, hold on. Is Ariana Huffington, is she in charge of the Huffington Post? I don't know who she is. Yeah, she started all of that, but then I'm going. Yeah, we're gonna have to go watch that again. Disturbing the peace. Okay. It's yeah. The this okay. Let's get through the rest of this. All right. Even if respondent denies authorship, the operator's admission combined with the subpoenaed platform data will demonstrate that he knowingly supplied, approved, or facilitated the release of private and litigation sensitive materials. Such conduct is directly relevant to the permanent renewal of the protection under Family Code 6345, as it shows respondents' continuing pattern of coercive control, reputational abuse, and disregarding for court orders or disregard for court orders. Well, that's something. That can't wait to find out how that goes down. Like, I know what Huffington Post is. I just didn't know that Laura was like besties with the people, or I didn't know she was besties. Okay. Let's remove this one, and then we've got one more document to go over. Kind of get through that one. It's her exhibit list. Okay. This one's 7 pages, but we should be able to get through this pretty quickly. Yeah, I am staying tuned definitely for that whole whatever facade that she's doing there. I mean, she could just be putting that in there as a way for her to get this out to the public, even though it might not actually happen at the hearing, but it's a way for her to just say whatever the hell she wants in a public filing. But oh, her dad interviewed Huffington in 2005. Okay. Somebody said Huffington is 75. Is that true? All right. Petitioner's exhibit list. She has the domestic violence restraining order, which includes the original 2018 order, the 2020 renewal, and petitioner's 2018 declaration establishing the factual basis for protection through July 10th, 2025. Related protective orders against Clayton Eckert and Greg Gillespie. Copies of active protection orders issued by other courts involving the same or overlapping factual circumstances, demonstrating the continuity of respondents' coordinated actions with individuals subject to these orders. Declaration of Laura Owens 2025 with exhibits. Filed in support of renewal, detailing respondents' continued violations of the 2020 DVRO, reputational attacks, indirect contact through third parties, and ongoing emotional distress. See, all she has is speculation on the metadata thing. She has no proof of any of that. Declaration of Attorney David S. Jingers, Esquire, with exhibits, describes respondent's unauthorized appearance at June 10th, 2024. Well, the judge said he could be there. In Owens v. Eckerd hearing, despite counsel's written assurance he would not appear, and documents his participation in social media harassment, including his public May 6, 2024 comment tagging at TED and at TEDx official demanding a removal of petitioner's TEDx talk. documents his participating in social media harassment. What? Okay. That us trying to get you removed off of TEDx is not harassment, but okay. Video posted by Clayton Eckerd, June 9th, 2024. Instagram video showing respondent with Greg Gillespie in Arizona. One day before Owens v. Eckerd hearing, demonstrating coordinating conduct and disregard for court boundaries. You know what the police said? Not a violation. Maybe get some of those police officers to come in and testify. Video respondent present for Arizona paternity case against Clayton Eckerd, June 10th, 2024. Video with witness confirming respondent's presence during petitioner's paternity case hearing in Arizona despite the San Francisco DVRO's no contact provision and knowing he was not going to be testifying. Article and video, exclusive interview, second victim of bachelor false accuser speaks out. That was posted on June 28th, 2024. Interview hosted by Megan Fox, in which respondent calls himself petitioner's victim and repeats defamatory statements showing indirect contact and reputational abuse in violation of the DVRO. Him doing an interview about you is not indirect contact. Because Megan did not contact you. Like, she just interviewed a guy. That is not. Because if doing interviews and saying crap on the internet, you would have violated Clayton's order against harassment against you. This is a crock of crap and you know it. The YouTube video breaking Bachelor Clayton's accuser has texts exposed from previous boyfriend, 2024. Video with 17,000 views, spreading fabricated messages attributed to petitioner relying on leaked material traceable to respondent or his relatives. His relatives have nothing to do with anything. They're fabricated messages? Are they? I don't think John Berryhill is going to say that they're fabricated messages. Website and archive, victim of Laura Owens, including Michael Marraccini and comprehensive timeline. Consolidated exhibit of the whole website's pages and posts containing over 2,000 leaked text messages. Commentary and defamatory narrative published between 2023 and 2025. That is nothing to do with Mike. Content mirrors private material in respondent's possession, showing direct or family-assisted dissemination of confidential communications to damage petitioner's reputation. Respondent's leaked video of petitioner's fall, June 17, 2024. Video uploaded online showing petitioner's fall off a horse in June 2017. Footage exclusively sent to respondent. Released to humiliate and discredit her. Okay. Respondent knows that petitioner's business is selling horses and that her reputation as a good rider is key to her doing that. Leaking this video is damaging to petitioner's reputation. No, it's not. It's you fell off a horse. Shit happens. And so you do have a business selling horses. That's interesting. But you have no money. So you admit you have a job selling horses right here. 11 posts by respondent's sister, now Scanlon, under the Reddit username Justice for MM. Compilation of Reddit comments from respondent's sister. Mike is not his sister. And his sister is under no orders to be quiet. She has a First Amendment right to speak out about her brother and what you've done to him. Yeah, she ruined her reputation. Nobody else. No, Judge Mata is not on the witness list. Yeah, this is in. I think she filed all this to definitely smear and take shots at people. Yeah, it's not in direct contact. That's so stupid. Yeah, she talks about coercive control. She wants coercive control. That's what she's trying to do on the internet. Yeah. Yeah, it's about it's about her fees, not the truth. Nope. Yeah, it's damaging. Then you need to sue for defamation. We've talked about this in the original filing because she also has talked about this in other things. In multiple posts, Miss Scanlon publicly identifies respondent as her brother. Mike is my younger brother, and I could not be prouder of him. Oh my God, a sister that's proud of her brother. Oh my gosh. Call the FBI. No, actually don't. Do not call the FBI. Laura, stop bothering them. And asserts after his June 28, 2024 interview with content creator Megan Fox that he is finally allowing to speak for himself, falsely suggesting that San Francisco restraining order is no longer in effect. She never said that it wasn't in effect, but he is allowed to tell his story. It is not in the restraining order that he's not allowed to mention your name ever. Because that would be unconstitutional. But you want to take away his constitutional rights. It's not happening, Laura. He has a First Amendment right to speak. And he's not contacting you and trying to speak to you. And he's not telling other people to speak to you. Her comments further include targeted attacks against petitioner and her family, such as her parents bankrupted themselves because of her lies. Okay, she's allowed to have that opinion. Laura's whole family is toxic, and repeated demands to take down your fraudulent TEDx talk, Laura. That's a matter of opinion. I don't see anything wrong with that. These posts demonstrate direct coordination with respondents and ongoing effort by his family to harass petitioner, spread defamatory claims, and misrepresent the status of a restraining order. She never said that the restraining order was lifted. He just is allowed to talk about it. Such conduct constitutes indirect contact and disturbing of the peace. Okay. You disturb our peace. Screenshot, respondent leaking private photographs. Image confirming respondent's release of private and explicit photographs of petitioner. Constituting a direct violation of DVRO and continued psychological abuse. Okay. Folder respondent sharing private photos and videos on Discord. Honk my meat. Screenshots and chat logs showing accounts linked to respondent disturbing private media of petitioner and her family on Discord, causing reputational harm and emotional harm. Who gave them the invites to Discord, first of all? How did they get those? Communication between respondent's ex-partner, Callie, and Owens, which is their Facebook things. Declaration of napkin lady. The CPS and HR records pending a subpoena. So she doesn't even They haven't even responded to the subpoena, and I don't think she's issued a subpoena for them. Maybe she has. Don't you have to file subpoenas with the court? Transcripts and video of Owens v. Eckerd post-trial interview with Marraccini. Okay. Post-media trial constitutes indirect contact, violations in the spirit of the restraining order, and evidences an ongoing campaign to publicly humiliate and intimidate petitioner. Bachelor Clayton isn't alone. Wild text revealed from victim 1 year before. So this is a Dave Neal video. Screenshot. Respondent comment on Instagram. Under Clayton's verified post, respondent publicly tagged TEDx, writing "Enough is enough. Take down her completely fabricated TED Talk X about me." No, it does not. There was no contact when he's told TEDx. He tagged TEDx, not you. Good God. Screenshot of respondent calling petitioner dangerous. Well, I believe you are. You're a danger to men. Joan O'Neill. We're scrolling right past that shit. Instagram account, Justice for Clayton. Compilation of select posts from Instagram. Yeah, I don't think you should. I think you also need to show non-selected posts, because they report on actual stuff too. I think it's used as a proxy to continue respondents' harassment and reputational attacks. Okay. She says their exclusive possession of family or Mike. They're false, humiliating, and inflammatory. Well, you're going to have to prove that they're false. Serial liar, mentally unstable, and dangerous. Hashtags. Okay. Posts published in close coordination. Own appearances, comments, or his family's online activity. Private your online activity if you don't want people to know about it. That's your fault. The consistency in tone, timing, and use of private material establishes that respondent or persons acting under his direction. Nobody is acting under anybody's direction. The Instagram account stuff. The account presents itself as representing respondent's side of the story, repeatedly referring to him as a victim, an echoing phrase used by respondent and his attorney in filings and media interviews. Okay. So Megan Fox is the media here, but she's just a YouTube person any other time. But okay. Posting, quoting specific lines and claims respondents' court filings and media statements include false assertion that petitioner filed fake pregnancies and restraining orders and that her parents went bankrupt because of her lies. Okay. Those are, to me, true statements. She thinks that the timing is crazy. Voicemails from Peggy Marraccini to petitioner, which those had been released because Gingras released those on Twitter. Okay. While recorded prior to 2020, they remain relevant and admissible under Family Code 6345. Why do you still have those saved? That's weird. But you don't have access to other things. So, yeah, I think so too. It's funny that she doesn't have Jan as a witness listed. I think Jan should be a listed witness, in my opinion. Yeah, she thinks, yeah, I didn't see anything that had to do with him breaking. Yeah, he thinks this is not a defamation case. And you have to prove these things. And it sounds like you don't even have the evidence to prove this stuff up. You're just speculating and writing a bunch of shit. But she needs to ask the court if she can go to her own hearing in another state. We'll see. I mean, I'm sure the court will allow it, because the prosecutors are gonna be like, yeah, sure. Go testify under oath in another state. Sure. This is just going to be more information for us to take. And her reputation is ruined because of herself, not anybody else. She just doesn't like the narrative out there. And she does not understand what harassment is. People are just reporting on a story. Yeah, she doesn't have her sister. I mean, I didn't expect her to have her dad. I expected her to have her mom. But yeah, this is gonna be interesting. I hate that I'm not gonna be there to see it. But we have Steve that's gonna be there reporting. I think Lauren is gonna be there as well. And then Megan Fox will be there. So we will have plenty of people reporting on this. And then it's interesting, she did not put herself as a witness. And to me, if she tries to plead the fifth because of an ongoing criminal case, that's going to probably be a problem, because she's got to be able to prove this up. So it is going to be very interesting, because there's a lot of things that I just don't think she's doing and should be doing. And David Gingras should be telling her she needs to have done these things. And maybe she's just not listening, but we'll see. Is this her last way to say her side before she drops the case or doesn't show, or tries to just be on Zoom, even though the judge told her she can't do it via Zoom? Because if she's like, well, I can't leave the state, well, Omar's going to be able to say she didn't even request to leave the state. She made no effort to do what you told her to do, Judge. Yeah, it's hard to keep up with lies. And all she has is speculation, and that's it. But that is going to be it for me today. Thank you guys for joining me. I don't know if there will be anything else that's filed in this case until next week. But thank you, and I will see you in the next video. Bye.
I may be angry, jealous, or in love. Make sure outsiders don't ruin the reputation and reveal our secrets. They need to be stopped, or the truth will come out. Motive means opportunity. I have the knowledge, the skill, the support, the tools to become a killer. Motive means opportunity. Now the opportunity reveals itself by time and a shady alibi. I have no reason to explain the things that I do. Can I do the crime in the time? Can I cover this up, or does this mean we're corrupt? Motive means opportunity. Do I have the motive? and the opportunity. Motive means opportunity. Now the motive, the means, and the opportunity. Motive means opportunity. I have the knowledge, the skill, the support, the tools to become a killer. Motive means opportunity. Now the opportunity reveals itself by time in a shady alibi. I have no reason to explain the things that I do. Can I do the crime in the time? Can I cover this up, or does this mean we're corrupt? Motive means opportunity. Do I have the motive, the means, and the opportunity? Motive means opportunity. Do I have the motive, the means, and the opportunity? Motive means opportunity.